In particular, Ripple has addressed the remedies aspect of the SEC lawsuit against the company in a letter that it has delivered to Judge Torres. These letters were sent by Ripple. Ripple submitted a notice of further power in relation to the consent judgment that was issued by Terraform Labs. A description of the recent occurrence was simultaneously provided by Bernie James, K. Filene, who is the representative of the XRP community. In light of a recent occurrence that attorney Bill Morgan was made aware of, this update has been created in light of the information that was gained. The bullet points that are listed below. For the key emphasis points of the movie, the Securities and Exchange Commission has filed a civil fraud lawsuit against Terraform Labs, and the firm and its former CEO, Doan, have negotiated an agreement to pay the SEC $4.5 billion. Both of these events are discussed in the video. Additionally, this amount takes into account the interest that is accrued on civil fines for discrimination and deterrence. Furthermore, Terraform Labs is confronted with the Terra Luna conundrum, which is the initial important challenge that surfaced when the market began to collapse in the year 2022. This challenge, which was offered by Terraform Labs, appeared to be the first substantial impediment that the company encountered. The judge in New York, who is in charge of the case, must still grant his consent before the deal can be finalized. This is necessary before the settlement can be conclusively determined. Under the terms of the deal, Quan and Terraform Labs would be permanently barred from buying and selling securities related to crypto resource assets. The Securities and Exchange Commission has made the decision that they are unable to sell something that does not exist, despite the fact that the video explains that there is no such thing as crypto asset securities. It is still necessary for the judge in New York, who is in charge of the case, to grant his consent to the settlement, and this does not affect the fact that this is the situation. The implementation of the agreement would also make it difficult for Quan and Terraform Labs to ever again buy or sell securities that are related with crypto assets. This would be the case if the agreement were to be applied. The video also mentions that the New York judge who is in charge of the lawsuit must still grant his consent before the settlement can be finalized. This is something that is addressed in the video. For the time being, this is something that is necessary. A statement that is made in the latter part of the film asserts that investment contracts are in existence, however, crypto asset securities do not appear to be in existence. As a result of the fact that Terraform Labs has been involved in two huge fraudulent schemes, it would appear that the Securities and Exchange Commission is attempting to acquire clearance for a final consent judgment in this particular instance. Defendants Terraform Labs Limited and doing responsible for willfully and recklessly organizing one of the most significant securities frauds in the history of the United States that has ever occurred. The Securities and Exchange Commission has made this request in response to a jury verdict that found them responsible for the crime. It has been brought to the attention of Judge Torres by the legal representatives representing Ripple that a notification of further authority has been delivered. As stated in the notification, Ripple has not been the subject of a single fraud complaint that has been lodged against it. This is crucial because in the case of Doan, Ripple was involved in a considerable amount of true fraud that resulted in the temporary collapse of an industry. This made the situation far worse. The significance of this evolution can be attributed to this particular cause. As part of the proposed settlement order, both of these payments are required to be made. Additionally, a deterrence payment of $3.58 billion is included in the settlement decree. In spite of the fact that the Securities and Exchange Commission has claimed direct witness testimony of investor losses, no one has experienced any financial losses throughout the whole of the SEC Ripple investigation. There was not a single claim made by the Securities and Exchange Commission showing that Ripple was directly responsible for the financial losses that its customers experienced. Moreover, the SAC Ripple case did not result in any monetary losses for any of the parties involved. The fact that the Securities and Exchange Commission is attempting to impose a civil penalty in the Terraform case reveals that, in accordance with the principle of proportionality, the civil penalty that the SAC is attempting to impose in this matter is severely disproportionate. Terraform is the only firm that successfully fits the pattern in this particular instance, despite the fact that the SAC has reached a deal with the defendants to levy civil fines that vary from 6 to 1.5% of their gross revenues. On the other hand, the Securities and Exchange Commission has proposed a civil penalty that is much larger than the range previously mentioned. Despite the fact that there are no allegations of fraud in this particular instance, and that institutional buyers did not incur considerable losses, this suggestion is nonetheless given. In light of the fact that the plan put forth by the Securities and Exchange Commission is not only illogical but also unprecedented, the legal team representing Ripple has confirmed that the proposal ought to be rejected by the court. Furthermore, they have admitted that a civil penalty that is appropriate would not be more than $10 million. In that particular instance in Terraform, they are referring to facts that pertain to the proportion of gross sales, which is within the parameters provided by the standards for prosecuting that are established by the SEC. In other words, they are referring to the fact that the percentage of gross sales is within the parameters. When contrasted with other instances in which the Securities and Exchange Commission has been a show regulator pursuing headlines rather than good policy, the harshness of the sentence in the Ripple case is noteworthy because it is radically out of whack. This is because the case involves Ripple, which is a cryptocurrency mining company. The cryptocurrency exchange known as Ripple is a company that focuses specifically on cryptocurrencies. The decision of the Securities and Exchange Commission (SEC) to seek a civil penalty is much larger than the range of 61.8% of the defendant's gross sales, which constitutes the precedent that was established by earlier cases by the SEC. When compared to the precedents that was set by other people, this stands in stark contrast. In addition, the Securities and Exchange Commission's decision not to pursue such a punishment represents a major departure from the precedent that has been established. Bill Morgan, an attorney, has expressed his disagreement with the stance that the Securities and Exchange Commission has taken regarding Ripple. The range of fines that were approved in past cases involving cryptocurrency, according to Morgan, was between Saxon and 1.8% of the defendant's gross sales. Morgan's argument is that this range was approved in the case of Terraform, which constituted one of the most important securities frauds in the history of the United States. The Securities and Exchange Commission accepted a consent of the whole sales of Terra. This was approved in the context of the case. In accordance with the criteria of the standard constraints, this punishment is appropriate. It was maintained by Ripple that the penalty of $876 million, which is being sought by the Securities and Exchange Commission, was 20 times larger than any previous punishment that has been handed down about cryptocurrency concerns at the time. Morgan is of the opinion that Al Whale's attitude against the cryptocurrency is the driving force behind the steps taken by the SEC concerning Ripple. According to him, this specific sort of punishment is unreasonable, and if the judge were presiding over this case, they would be thinking that there is something else going on in this set of circumstances. In his opinion, this particular sort of punishment is not a logical means of punishment. In his answer to Morgan's essay, Mark Fagel, a former attorney for the Securities and Exchange Commission, remarked that the penalty in Terraform is a bit of a dream in any event, given that it reflects closed cases rather than actual money. Fagel's statement was made in reaction to Morgan's essay. The comment that Fagel made was in response to the essay that Morgan had written on the other hand. He admits that Ripple did not negotiate a settlement, as well as the fact that the degree of disproportionality is exceptionally high in comparison to the norms that have been established in the usual manner. An announcement that was made not too long ago by Brad Garlinghouse, the chief executive officer of Ripple, suggested that the Securities and Exchange Commission will most likely collect a penalty of $100 million by the time the summer comes to a conclusion. It is important to note that this amount is much smaller when compared to what the SEC is demanding. Morgan further indicated that Ripple did not engage in any criminal behavior in the Terraform case and that the judge's judgment was made on the institutional side, which is something that does not impact in any way for any particular XRP holder. Morgan's statements were made in reference to the fact that the judge's decision was made. Another attorney by the name of Mark Fagel said that the Securities and Exchange Commission might not be able to obtain anything even close to what it wants, despite the fact that he admitted that there needed to be some mercy for accepting guilt and settling.